Hello everyone, welcome back to Law, Crime and Punishment, Week 11. The title of today's lecture is The Commonplace of Law, Part 2. And as that title hints, today we continue our journey into The Commonplace of Law, the book written by Patricia Ewing and Susan Silby back in 1998. Last week we read excerpts from Chapter 3 of the book titled The Social Construction of Legality. And for this week, Week 11, we read Chapter 6, Against the Law. In today's lecture, we're going to focus on legality, that is the structure, and the three types of legal consciousness, that is the agency, and clarify what these two concepts mean and what type of connection exists between the two. I want you to keep in mind that last week we revisited the concepts structure and agency and examined the two parallel concepts from the realm of the law, which are the legality and legal consciousness. Let's begin with legality. In short, legality is the legal structure within which we operate. Now, that begs the question, what is then the difference between law and legality? The distinction between law and legality is based on the type of actors and scope of actions included. What is usually referred to as legal relates to practices taking place within the confines of legal institutional settings, for instance, the courts, and carried out by formal legal actors such as judges, lawyers, and other official representatives of the legal system. The concept legality seeks to broaden that rather narrow scope by transcending the traditional demarcation between legal and non-legal actors. Instead, legality refers to the, quote, meanings, sources of authority and cultural practices that are commonly recognized as legal regardless of who employs them, end of quote. It refers to a broad set of social practices which, while not being legal per se, are carried out under conditions that are already saturated with legalism. Legality, you can simply conclude, is a, quote, social structure actively and constantly produced in what people say and in what they do. Legality, then, is a structure that is constantly being reproduced by the active participation of ordinary people like us. In other words, people participate in the production and reproduction of the very structure that constrains them. Think of the marine biology example here. Ewing and Silby's theory focuses on the various ways in which ordinary people's experiences, actions, conversations, interpretations, and thoughts serve to produce and reproduce legality. That is, law's legitimacy as a governing institution, the structure. People's participation in this reproduction, their legal agency, if you will, is what Ewing and Silby term legal consciousness. Now, Ewing and Silby classify three types of legal consciousness. That is, three different ways that characterize how people act and think and feel about the law. It's before the law, with the law, and against the law. And we're going to go over each one of those now. Before the law is an attitude toward the law that sees it as grander, powerful, and separate from normal life. Law is understood as a hallowed, sacred space. It is respected, believed in, and followed. It's the kind of attitude toward the law that is reflected in the first part of Millie Simpson's story. Upon entering the court, Millie Simpson believed in the process. She followed its rules and deferred to its procedures. Even the form of her story revealed her submissiveness and deference to the law. This is a world in which things happen to people rather than one in which people do things. For Millie Simpson, the order of things, the power of the court, the comfort and ease with which rich white folks negotiated these matters was simply there. It didn't need to be stated. With the law is another form of legal consciousness, another way to characterize how people act and think and feel about the law. Here, the law is acted upon or played, quote unquote, as a game. It's got its own rules, procedures, and norms, and in order to win, one must first figure those out. In other words, instead of being in awe of the law is seen as a contest that needs to be played in a smart, smooth, elegant way, a contest that ultimately needs to be won. That is exactly what Millie Simpson did after her initial loss at the courthouse. But Millie Simpson did not simply stand before the law, submitting to an external and powerful authority. She also contested its findings. Millie returned to the court several weeks later, this time with an experienced attorney. Armed with the Richards family's assistance, Millie returned to engage the court on its own terms, within the law's terrain. Finally, the third type of legal consciousness refers to situations where people feel trapped, stuck within the confines of the law, not able to win legal battles when they are operating according to its routine rules, norms, and procedures. Alternatively, people seek ways to exploit the, quote, interstices of conventional social practices to forge moments of respite from the power of the law. Foot dragging, omissions, ploys, small deceits, humor, and making scenes are a few examples of resistance for those up against the law. And again, going back to Millie Simpson's story, the following quote reflects her attempt to manipulate the law and work it to her advantage by arranging that her community service be done at her own church. Remember? For most of those without power or position, the only alternative to conformity is resistance, poaching, appropriation, or silence. By suggesting her church work as fulfillment of her legal obligation to perform community service, Millie Simpson successfully insinuated her life into the law space of the law and, in doing so, reversed for a moment the trajectory of power. So these are the three types of legal consciousness. In next week's lecture, as stated earlier, we will examine how these three types of legal consciousness work together to produce what the authors refer to and call legal hegemony. That is it for today, folks. I hope you enjoyed the lecture. Take care.